This is 114-1484-23, State of Texas versus Jesse Williams. Ms. Melantree, we're here on your motion to reduce bond. So
yes, Your Honor. I've spoken to Mr. Knoll regarding this matter because I had a chance to go and visit with Mr. Williams, in which Mr. Knoll stated I could go ahead and file a motion. I'm his co-counsel, but when I do things, I get permission first to see if he's in agreement with it, and which he is, and so I have submitted a motion to reduce Mr. Williams' bond. I had an opportunity, and I reached out to possible witnesses to come forth to testify regarding their means of funds to pay for the present bond, in which they stated they were on fixed incomes, or that they were not selling a house to pay the bond that has been set by the court. And they also tell me that they really just did not have any money. Therefore, Mr. Williams is requesting a PR bond from the court along with the monitor. I told him that may not be possible, but at the same time, I have filed a motion for the court to consider to give him a PR bond, but he also knows the possibility that that bond will be denied.
So there is some reference in the motion to a $300,000 bond. Are you saying now y'all don't think they could make that? It would
That's correct.
have to be a PR bond.
He informed me that they could, if we got it down to $30,000, well, $300,000 making $30,000, they could do it. So then I called the mother. At the time, she was willing, and then she changed her mind.
Okay.
And that's where he had gotten it from in order for me to file it.
All right, Mr. Mickelson.
The state would offer B1 is going to be the probable cause affidavit, the arrest affidavit, rather, and B2 the criminal history of Mr. Williams.
Yes, sir.
I'm tendering copies to Mr. I know you already. Is there any objection to the?
I'm sorry, Mr. No objection.
Be admitted, and B2 will be sealed. And I'll copy that for you.
Other than that, the state doesn't have any additional evidence in this case.
All right, Ms. Melantree, anything additional?
No, Your Honor, we rest.
All right. The court having reviewed the evidence, and obviously I'm familiar a little with this case because I did sign the original arrest affidavit, which I've reviewed again here. Also take note in the criminal history, which is fairly extensive. There's also multiple failed IDs, including at least one failure to identify when it appears he had a warrant out, which causes, of course, the court concern. And based on the totality of the circumstances, I'm going to find the current bond is reasonable and necessary to ensure cannot make the current bond, but it does not appear that the bond could be reduced to an amount that he could make that would ensure both a return to court and protection of the public. If all we can do is a PR bond, I don't think that's appropriate under the circumstances and doesn't meet the statutory considerations the court is to consider when setting bond. So at this point, I'm going to deny the motion. Do we need anything else? Looks like it's already set for the hearing in January.
It's already set, Your Honor. I think it may be pushed back, but we're going to start doing the discovery. Last time that we were here in court, Mr. Williams, and for the record, I went to go visit with Mr. Williams. He did come down compared to when we were last time. And Mr. Williams is now ready to start reviewing his discovery.
And we will, Ms. Melantree is co-counsel with Mr. Knoll, and we'll open up so that she has free access to it and doesn't have to go through Mr. Knoll for the discovery. And just an oversight on our part. We'll get that done. The only outstanding discovery that we have that I'm aware of is DNA testing that's pending, swaps from the supposed car of the victim. We haven't gotten those back yet, but of course, as soon as we get them, we'll get them to the defense. If we can expedite the trial, that would be great, but otherwise, we have a trial sitting in March. I think we're looking good for being ready at that time.
All right.
And the best part is getting that discovery.
And Mr. Williams, I'm glad to hear you're now talking with your attorney. Obviously, I can't tell you what to do, but I can tell you that given my experience of being where Ms. Mellentry is and then sitting up here, I have never seen a case with a good outcome where the defendant didn't cooperate with his lawyers. And so that doesn't guarantee any particular outcome, but it does mean that whatever comes, I think you'll feel better about the outcome if you work with your lawyers and give yourself an opportunity to share with them any information that you may have. So I hope that continues. Anything else?
No, you're not gonna talk about it. No, we don't do that.
All right, we'll be in recess. Thank y'all.
Okay.
Thank you, Ernest.
Yes, ma'am. Thank
Y'all
you.
have a happy Thanksgiving.
You too.